Alex here. We are live with Rob, and we are going into Viewers Victory number 6. Usually I go into a little bit of an introduction, but Rob has a unique story, and so I'm going to let him go into his introduction. And I just want to let my viewers know that this is going to start out, at least, with the perspective of a person who faces challenges outside of the courtroom. And what I mean by that is even before he's actually able to get in front of a judge, his ex is leveraging outside of the courtroom, sometimes what I call extrajudicial tactics to win the case by not even going into the case. Most of my viewers know that I kind of went through that myself as well in my own case. Mainly it was efforts by my ex to psych me out. But with that all being said, why don't you go ahead and introduce yourself, Rob, and sort of let us know kind of those initial challenges that you faced.
Yeah, thanks, Alex. Rob here. Glad to be invited to the channel. Could you hear me fine?
Yeah, I'm picking your sound up good. And by the way, guys, he's anonymous, of course, because he doesn't want this to impact his case.
Yeah, so I had a little bit of what some would say a unique situation, to say the least. So when I had initially met my baby's mom at the time, I was basically had a warrant, and I was in a situation where, basically I had legal troubles in that sense. And because she knew about that as we got together, that basically became a constant threat in the sense that, basically I'd been on the run because somebody had put their hands on my brother who was a child at the time, and they kind of alleged some different things. And that kind of changed the next 6 years of my life. So we had met, and then from there, basically it was just she kind of used that as a lever to control my every move, and basically saying, hey, I can just tell the cops you're on the run, or anything like that. So I was there when she was born. I cut the cord. I was there, but the past did ended up catching up with me. I did beat the case, but I got caught with a firearm. Went to prison for 16 months. So that's kind of gets you to the present before we even get into court. So a lot of people go in with, some baggage or things to overcome in court. I had an immense thing, a ton of stuff. So from there, um, I got out. I was seeing my daughter on the weekends. I had a great job. I was doing things really well as soon as I got out, but it became this thing where no matter what, if she decided how things went. She couldn't talk to my family. I could only take her here. If I was with somebody, that female could not be around her. And anytime I did anything like that, or had her talk to her grandma, for example, it would just be, hey, I'm going to come get her. I'm going to send the cops over to your house. I'm going to hit you with child support. And it was just on and on and on and on. And it just never stopped. Fast forward to one day, I get a text basically saying she's going to jail for domestic violence. And this was with a boyfriend that she was with, told me to come get my daughter. I went over there and got her. And then from there, it became, okay, I need to just file the papers. Who cares what happens? We'll just deal with it from there. I did that. And then, initially going into that, I had filed and told her about it. I was very transparent. And Alex, if you want to break in with questions at any point, I don't want to just feel like I'm droning on. Let me know.
Well, the first question I have is I did the same thing. I warned my ex that I was going to serve her. Did yours then try and hide? Because that's exactly what mine did to evade service.
Yeah, this one actually wasn't because she was in jail when she got served.
Oh,
So it was,
okay. All
yeah, it
right.
was pretty easy to serve her. But I didn't have it as a surprise. And what I mean by that is, she had called my phone. I'd put money on the phone so she can talk to me. And then when she got out, I actually ended up picking her up from jail, which was a little bit of a bonehead move, but she had nowhere to go. And I was just, I just did, picked her up so she can have a place to stay. Well, we ended up going to court, and actually, that for the serving of that paperwork, I literally just had the sheriff hand it to her right there, and just got signed before we went in the court. So everything was like super smooth when we did it because I told her like, hey, I'm not trying to take our daughter from you. I'm just trying to make sure that one, I got rights, and two, like if situations like this ever occur in the future, that because I wasn't on the birth certificate, that I'm there to step in to make sure she's safe. And I think we kind of both care about that. So that went into effect. We started going to court, and then it was kind of the same thing erupted again, um, and it just devolved into this situation when she was staying with me, to where, because I was on probation, she would threaten with bringing things into the house that would get me locked up. Saying that she'll do something to get me locked up, and it was just this ongoing thing, and it was so high conflict that ultimately what happened, she went to jail for the second time for domestic violence with me, and the situation didn't even need to go to how it went. But as soon as it did, I basically had just started recording it. And it started with her thinking I was in her Facebook. And then from there, me trying to leave, to her doing exactly what she had did like 45 days prior, right in front of our daughter again. And because I had audio and video set up in the house because I didn't trust her, that's really what saved me, because I even had her on video saying that she's going to tell the cops that I hit her, that there's drugs in the house, and just all these things.
So I had a couple things. The first thing is you mentioned how it was a bonehead move to pick her up from jail, but I did a similar thing because mine ended up going into a 72-hour hold at a mental health facility. And I don't know how it worked with you, but it's kind of like they try to paint, I don't know about for you, but she tried to paint me into this corner of a person who was scheming and going to take advantage of the situation. And it's like they trigger this response. I don't know about you, but again, like with me, to prove her wrong and to be like, no, I'm not trying to do that. We are going to raise him together. And so I went and, I helped her out as soon as she got out of the mental health facility. I took her back. And it's very similar in my situation, where I could have just said, you know what, this is it. I'm going to go ahead and file the papers now. And it's kind of like, to me, sometimes I wonder if they sort of think other people are like them. And I don't know if you feel the same way now in hindsight, but for me, looking back over the years, I feel like a lot of the things that she accused me of were the things that she herself would have done if she could have. But unfortunately, at least unfortunately for her, she was the one that was in the bad situation because of her conduct and her bad choices. I don't know if you can relate to any of that, but it was a similar situation there with me. And then the other thing that I wanted to mention was using those outside the courtroom tactics to win. I know that that's something that a lot of the viewers can relate to. And so it sounds like she sort of took advantage of your situation with regards to you being on probation, and kind of indicated that she would do things on purpose to get you arrested so that she could win her custody case that way. Is that kind of what you were getting at there?
Yeah, I mean, it all happened really quick. So she had basically been, arrested with her ex for domestic violence, and then 43 days later, the same thing happened with us, where she was arrested. Both times, like, the DA didn't pick up charges against her, so none of those things really had any type of weight in the custody procedure. But what happened with us prior to the whole situation happening with us and her getting arrested is, I picked her up from jail, and it was this kind of thing where, she has a lot of charm when she wants to. She can be, you know, come off as a very good person, and she can listen at times, right? So I think the act of me going to get her, and her understanding, I guess, with how a lot of people in those that think like that is, I think she felt I had leverage. So she was kind of using it because she knew that, hey, I had a place for her to stay. She didn't have nowhere else to go. And then me kind of being an idiot thinking, hey, everybody can change, obviously, because of my situation, even though it's not like I was like some dirt bag on the run. It was what it was. But I just felt that, like, hey, why can't we kind of come together and just do what we got to do for our daughter?
Mm-hmm.
So when we went into that initial custody thing, I basically did the dumbest thing in the world. I agreed to her being the non-custodial parent, and I agreed to weekends, because prior to any of this court stuff happening, I was seeing her on the weekends, right?
Mm-hmm.
And part of me felt that, hey, this is me giving you confidence that, hey, I'm meeting you halfway, in the sense that exactly the same scenario we had before all this happened is the same scenario that exists today. But also, I didn't understand the true impact of her being the non custodial parent. And it wasn't even apparent because I was literally taking care of both of them.
Yeah.
So the moment that I agreed to that, though, and this is things that I was actually able to leverage a lot of this in court because California is a one-party or a two-party state. You know, people have to be aware that they're being recorded,
Hmm.
but because she didn't live with me, she wasn't on the lease, she didn't receive mail there because I was actually very specific about those things because I understood it, and I set things up because I just did not trust her. We got a long history, and all of that ultimately saved my ass because likely I would have been in jail, lost my career, lost everything I own
Yeah.
if I didn't have all that video.
Yeah.
But um, I guess to fast forward after that incident, I had again went back to court. I'd got full temporary custody. So I'd filed ex parte motion for emergency custody of my daughter. But because they dropped the charges, she got out. And later on in the hearing, they essentially just reverted back and gave me weekend visitation.
Oh, wait, let me correct you then. So earlier you were saying that you agreed to her being the non-custodial parent, but what you meant was you agreed to you being the non-custodial parent.
Yeah, yeah.
Okay.
I gave her everything she wanted
Right.
for the bulk of our situation because even after that whole incident, and it kind of went right back in the court,
Right.
um, they, as soon as they reverted it back after, the second time she got arrested, she, as soon as they took the emergency, like, I'd filed the ex parte, got emergency custody. As soon as they like revoked that back, I just at that point was like, you know what, I'm not going to be able to win. Like they're obviously, she's bulletproof. So I was kind of feeling defeated, to say the least.
Well, hold on a second. You said you had video evidence of the domestic violence, but, and this isn't your fault. This is actually something a lot of people are confused about. But nobody told you that in the family court you had an opportunity to prove the domestic violence, regardless of what the police did they?
Yeah,
Nobody
and
told
that's,
you.
yeah. Nobody told me. I found out later. There's a family code 30. I'd have to look it back up.
It's
It's not.
fine, but it's you have a right to prove it in your civil action, and you have wonderful evidence, and it's just one of those things that a lot of people are fooled into believing is it's all up to the police, and if they drop the charges, you can't do anything, which is completely false. And
Yeah,
the judges feed right into it. You think that the judges would want to actually get to the bottom of this because you have seen the damage that it causes your child to see domestic violence happening right before her little eyes. And you think that the judges would be like, okay, well, it's fine, the police dropped it, but I want to know more. No, no thanks. Let's just go back, move on, next case. That sounds like that's what happened to you.
that was actually what was extremely surprising to me because in one incident I can see where, especially in domestic violence type situations, where there's going to be doubt cast on both people. But when two incidents happen with two separate people within 43 days, and one of them has audio, video evidence, and everything else that happened, I just like, it's like the court totally dismissed it, and I didn't understand why.
They don't
And
care.
later on, I found out that it's family code 3044 actually, and it's like where if the court can make a finding that domestic violence has occurred, then there's basically a rebuttable
Disqualification.
presumption.
There you go.
With,
Yeah, that's what it is. Yeah.
yep. And the judge, I found that out way later,
Hmm.
and it was kind of like those things because later on, and basically after this, she had filed a move away, and this is where things got where I still don't feel from a legal standpoint I was educated to where I needed to be,
Hmm.
but I was still knowledgeable enough at this point to understand, okay, I really need to start being more keen on documenting everything and just making sure that whatever happens in the future, I have this information organized now, and just really start digging into it. So she had filed a move away request, and this kind of came out of left field. She had family on the East Coast, and the reason she said to the court was she's getting married. Now, this was a completely new guy that just popped up out of
Hmm.
nowhere, and It's like the same judge just totally bought into it, and ultimately what happened, I agreed to it, but the reason why is we had went to the hearing, and back then I didn't understand the rules of submitting evidence and the different, what needs done at what time and all these things. I had everything organized, prepared, the audio, the video, the documentation, all the stuff, and I didn't serve her correctly. I didn't file it with the court correctly. So the judge essentially said, "Hey, doesn't matter. We're not going to hear it today." So I kind of made an on the spot judgment call where it's like, okay, I can let this hearing proceed and lose because I knew that when it comes to a move away request, the custodial parent has a presumptive right to move
Right.
with the child.
Right.
So I didn't want her to quote unquote win.
Mm-hmm.
So I just agreed and said, hey, you know what? Because I work online, I can move around and stuff like that. I was just like, screw it. I got to do it like this. It was kind of an emotional thing. Even she got emotional, and then ultimately, what? And this is the stuff that really helped me later. But she had got it granted. Um, Basically, it was granted, and also when the family court services, which is like the mediators in California, they had, basically said, the kids should stay with mom. Later on, though, because after this, I did move to the city that she moved to in the East Coast. We were talked about it. It wasn't me just like running over there chasing her.
Mm-hmm.
And she had actually sent me a message right after she had got married and right after she had moved, saying like, I want basically I want you here. I'm thinking about moving back to San Diego, so I have a safe place for somebody to watch our daughter. And this was all in messages, and it was just every 30, 40 days I just had some different type of message. And she ultimately left this guy she did marry,
Mm-hmm.
moved somewhere else. By this time I ended up relocating. I sold everything I owned, moved, and then as soon as I got out here, even though our agreement was basically set up where it's like me living on the other side of the country,
Mm-hmm.
so it's like visitation 1 week a month, in my community. That was our agreement. That where she would have to fly her out, and then I would have to fly her back, and then every other month I would basically have to fly out to her community, and I can just visit her there for 4 days. What really kind of prompted me to just move pretty immediately is the first time that visitation was supposed to occur, she missed it, and she missed it because I was involved with another woman.
Oh.
And that's been like, my daughter's been around a ton of different guys that she's been with, but I've only had two females around my daughter, and it's just so explosive with what happens.
Mm-hmm.
If my daughter says another female's name, even if I have no relationship with her,
Mm-hmm.
it's. Did you ever deal with similar things?
Yes, I did. In fact, mine had so many men that I didn't even know all of their names. And I had a single girlfriend who turned into my wife, just one, and she went nuclear. It got so bad that she schemed a plot to have my wife arrested. She there was an exchange that my wife had to go to because I couldn't get this one. And she had two of her coworkers come out of her workplace with her, and she started an altercation in front of them. Luckily, my wife did not take part in it and immediately left. And she called the VA police and tried to get federal police to press charges on my wife. When they called the two witnesses in, the her coworkers didn't lie for her. They told the truth and said it was all my ex. And so nothing came of that. But it really did open my eyes to just how insane she was going, just because of the fact that our son would come home to her in her and talk about my wife, and she didn't like that, and it drove her absolutely nuts. And she could also see that the relationship that she didn't ever have with him was beginning to form between him and his stepmom. I don't know if your significant other and your daughter have a good connection, but if that's the case, if they do have a connection at all, your ex, if she's got emotional immaturity issues, she'll notice that, and it threatens them, and they totally lose it. So you have a bunch of comments I'm going to go through here. First off, there's a lot of people mentioning that they were also saved by video evidence. Matt Mitchell says that. I don't know if you've seen Viewers Victory #1, but same exact thing there. Video evidence in both of those cases saved their butts. I didn't have video evidence, so I ended up with a TPO on me. And I cover those in My Docket series, parts 2 and 8, and also parts 3 through 7 cover the documents, but parts 2 and 8 have the hearings. And I didn't have any evidence. So he said, she gets a TPO. I was able to fix it after years and years, but that's just one of those things that happens. Be careful trusting somebody who has backstabbed you, because if they've backstabbed you once, they'll do it again. But it's good that you had that.
You know,
Um, Go ahead.
a little commentary that I think would also help viewers on that. Like, obviously around the whole DV thing, what saved me is video and audio and all that, plus another additional video of her right after her attacking me in front of my daughter, saying that I'm going to tell the cops that you hit me and I'm going to tell all this stuff, right? And then naturally, I was the one that called. And then when the cops came, she was going in the other direction. But when it came to that, another thing that helped me is now the laws are unique and it depends. So there's a lot of one-party states, and I actually continued to do this and was able to do it for my hearing here to just show a pattern of instability and a pattern of disrespect and a pattern of just kind of doing what she wants, because pretty much all our interactions, I'll just record them. Like, we're in one-party states now, so it is what it is. I just do it to make sure I'm protected, because I never know when things are going to crop up. But in
Mm-hmm.
that instance, being in California, it is a two-party state. I was able to kind of wiggle it through on that, because if they're not getting mail at your house, if nothing is set up in the sense that they live there, and in my instance, I picked her up from jail and she was staying there. It was a temporary thing. Just like you can have a nanny cam in your living room, and if that's something, you know what I mean? Like, nanny cams are legally admissible evidence if something was happened. If you use them, and like, let's say the nanny's beating up your kid or something,
Mm-hmm.
you can use that in court. And it's the same sense of, if you have somebody in your house, you can record, but you can't record in stuff like a bedroom or bathroom or things like that, because there is a expectation of privacy.
Right.
So during fights and arguments, or her just kind of running her mouth at times, I had just recorded. And it was just be able to show this pattern of just super vulgar talk that would happen in front of my daughter. And I can't diffuse it. The only thing I could do is just either leave the house or just shut up and let her eventually just stop talking, because to say
Mm-hmm.
anything back is just meaning, like, she's
It
not
makes
going
it
to stop.
worse. Yeah.
Yeah.
So we actually had a case here in Nevada where a guy secretly recorded his ex in violation of the law. And the Supreme Court of Nevada said that the state can prosecute, his ex can prosecute, but that is not their concern. Their concern is in the context of child custody, to protect the child. So despite the fact that he could have been prosecuted criminally or civilly, he won custody, and the Supreme Court upheld the decision of the judge, not only to allow a third-party evaluator to hear the secret recordings, but they found error in the judge's refusal to listen to the recordings herself. So it was harmless error because the dad won anyway. It had no impact on his case when he already had gotten what he wanted, which was primary physical custody. But it's a fascinating case because it can show you how sometimes the statutes that involve protection of children will conflict with the statutes that involve civil and criminal liability. And the Supremes in Nevada said, yeah, somebody might go after him for having done what he did, but we will sustain this child custody modification based on the secret recording, because it was so alarming to them and because of the legislature's policy. So there are some really weird, complicated issues out there with regards to recording. Megan had a comment touching back on the domestic violence issue. And she actually says that her judge believed her ex and said in court that something about the police not prosecuting or having no option but to prosecute. And I don't really need to get into the detail of what she meant there, because it dovetails in what I wanted to tell the viewers, which is, if a judge is not willing to hear domestic violence allegations because of something the police did or didn't do, that is reversible error. That will be overturned on appeal. And I always tell people to use the analogy with the O.J. Simpson cases, because the police there did prosecute and lost, and they still went after him civilly and won. It's the exact same principle that allows that situation to have occurred that allows us to prove our own cases regardless of what the state does in a criminal court. And let's see, we got a few other ones here. Let me take a look at some of these comments. Shay says hi. Our brand says something about video evidence is not admissible if res judicata applies. Enter into a mediated settlement to get to see children, then the evidence is no. Okay, so Matt, you're not exactly right. What you're talking about is one of two. I'm going to get technical. So Matt, you're talking about one of two species of res judicata, and you're talking about claim preclusion. And claim preclusion doesn't ordinarily apply in child custody disputes, but some states have enacted statutes that create something called the change of circumstance requirement, which is basically mimicking how claim preclusion works. Now, you're still only partially right, even if you're in one of those states that has a change of circumstances requirement. And what I mean by that is you are only blocked from using that video evidence to show a change of circumstances. If you have some other way to show a change of circumstances, then you are able to get to the best interest analysis, and then you can still show that video evidence even though it was obtained prior to that mediated settlement. Judges get this wrong all the time. And if you know how it works, you will get it reversed on appeal. It happens all the time in Nevada that judges screw it up. Somebody files an appeal because they know how it works, and it is overturned on appeal for all of the reasons that I just stated. If it's really confusing to any of my viewers, watch my video, Change of Circumstance. I explain it in detail. You can also watch my video, Claim Preclusion, which explains how claim preclusion works. If you're wondering what the other species of res judicata is, it's called issue preclusion, and it works completely differently. I'm going to continue on here. We got Matt B saying,
Something to piggyback on that too, that
go
I
ahead.
think people might find helpful, that even if the judge makes an error, which I feel happened with the first judge I dealt with, the thing that is the reality later on is I ultimately agreed to the move away request. So regardless if the situation happens or you have evidence, if you make any agreement afterwards, and let's say, I made an agreement afterwards and then things got worse again, but they still say when they go back to the best interest factors, well, hey, you agreed, so obviously you didn't take this stuff serious enough to oppose it at the time. Later on, I was able to use it to basically paint the history and use a bunch of other things that were actually pretty severe that came up later, which I think ultimately swung things for me to get full physical. But if you agree to something later on, it's, even if it's, you got good evidence, it's still kind of moot at that point.
Yeah, I get what you're saying because, and it's a common attorney tactic, and judges are former attorneys, so they're going to have the same sort of way of thinking. But yes, they can say something like, "Well, if it was such a big deal, you should have made a big deal about it sooner." The Supreme Court doesn't like that. When judges say that, they get they get overturned. But some of them say it or do it anyway, and sometimes you really have to connect with them and explain, at the time I really didn't have a way to win this because you didn't have primary physical custody, the relocation statutes were unfavorable to you. And sometimes they'll listen, other times they'll just say okay, whatever. And it's irritating, but that's just one of the things about judges. They're not always perfect. And I've had a couple of other notes here. I think it might be a good opportunity for you to go into the actual victory at this point.
Yeah. So what led up to things changing is, as I said, when I moved out here, basically on the opposite coast. I started getting my daughter Thursday through Monday. So this wasn't something that was like, that we agreed on. It was just like, she worked, those were her hours. And then, naturally I just started picking her up at those times. What I did that was very important that actually really saved me later is every time I went to go pick her up, I texted here and I let her confirm before I kind of went up to where she can come out and meet us, and vice versa when I dropped her off. So that's how I established a time log that was basically confirmed by her. Because later on, she said that I didn't get that much time with her, yada, yada, but I was able to come through and show that that was the case. So that's kind of what the situation was. After I moved out here and, basically changed my whole life and, moved out here to be with my daughter, she ends up starting to say, hey, I'm going to move to this other state now. Um, so she's saying she's going to move to this other state. And I'm just like, you got to be kidding me. Like, we're 15 minutes away from each other. Our daughter sees us both. Like, this is ridiculous. And she's, you know, well, it's only going to be for the summer. And I was like, well, you can go, you can leave her with me, and then we can work out some visitation thing, right?
Yep.
Um,
I put up your screen so people can see the visitation schedule you're talking about. But keep going.
yeah. So essentially, she ended up just going. She disconnected her phone, moved all her property out, quit her job, leaves to this other state, and well, actually, let me back up a little bit. As she was saying all this stuff, it was getting closer to the time she said she was going to go. So I went ahead and filed a modification of custody and a move away request to return back to where I came.
Mm-hmm.
So I'd filed that, and when I went to file that, because our home state was still California, I'd flew back there, did that. My daughter was actually with my mom when I did that, because at the time my mom was staying with me for a little bit. So as soon as I come back, I had my daughter, then took her to her mom. Like the next couple days, she ends up bouncing and just disappears. Well, it went from, and this is where the court was like, well, at first didn't do anything, and this is probably going to shock some people in terms of rights that you have, but um, she disconnected her phone, did all that stuff, and I went from seeing my daughter Thursday through Monday, literally from February 2019 up until June, um, to talking to her over video for a cumulative time of like an hour and 34 minutes in June. So she completely did not let me have no physical contact, did not tell me where she was, didn't do anything. And, I assumed, hey, I might be the non-custodial parent, but I still have visitation rights. Well, you actually don't even have that, because I had called 3 different states. I called the sheriff, police, CPS. Not one of them would do anything because I was not the custodial parent,
Mm-hmm.
and the court order didn't mean anything. I ended up calling the National Center for Missing and Exploited Children. They actually opened up a case, and then I ultimately had to fly back to California, get ex parte emergency custody, which was granted, which didn't matter because I didn't even physically know where my daughter was at, and then opened up a case with the DA Child Abduction Unit right there. But not a single one of these people or agencies or whatever even looked for my daughter,
Nah,
like not once.
they
And
don't.
yeah, I never would think that it would be like that, especially, you assume you're protected, but I ended up finding her
Mm-hmm.
because I essentially basically ran Facebook ads over the areas I figured she was at, offering $1,000
Whoa.
reward. And then I used been verified social media and essentially Zillow to kind of look the background from when I did talk to my daughter of what the
Right.
house looked like, pinpointed the address, got her served. She ended up appearing telephonically. Yeah, dude, it was crazy,
Wow,
dude. It was
that
like
is exactly what I
MacGyver
tell
stuff.
my viewers. Do it yourself. You turn the wheels of justice yourself. You filed all the paperwork. You did the investigation. No one cares more than you. Keep going.
Yeah, so that's how it ended. She ended up appearing telephonically at the next hearing for the follow up for the ex parte. The judge, which was a different judge than we originally had,
Mm-hmm.
he's the one that actually ultimately gave me full custody. But he did revert the emergency custody back and just said that, hey, here's the visitation schedule. She claimed she was on vacation. She's been in this other state like 5 months now. She's actually working there.
Mm-hmm.
But at the time, she told him, and this is what kind of killed it too, is she told the judge she's on vacation. She told him when she'd be back, and she'd also said the same thing in family court services.
Mm-hmm.
So, going up to this next hearing, I knew it was crunch time. So when I looked at how I had filed before, one of the things that I've kind of learned over time is the best interest factors are a close second to procedural rules,
Yep.
meaning proper forms and everything else, um, and making sure you're filing things on time and serving the other party on time. So um, when it got to that point, to the next hearing, I had already filed my modification of custody, the move away request, but I had this enormous amount of like, real solid evidence, and like that I actually hadn't really submitted, because at the time I was thinking, this is when actually I started really just consuming all your videos nonstop and just going through it, and then getting on Google and learning and reading case law. Um, so I ended up understanding that, hey, I can't refile this thing, but I can file basically a declaration in support of that motion, and I can introduce everything that way, and that's what I can go in and argue it. But
Mm-hmm.
my problem was, it ended up being it was like a 40-page motion. I just looked up, got some pleading paper online. Actually, I think you sent me a template, and then I just wrote and wrote and wrote, and then made sure I attached all the exhibits perfectly. And I had her served in one state while I sat in another, and used an attorney filing service to file everything in literally on the same day. I mean, it came down so much to the wire that on the last day that she needed to be served, and the last day that the things needed to be turned into court,
Mm-hmm.
I was in one state, and she got knocked on. She got served at the address she's never reported to the court. And then an attorney filing service filed everything in court there.
Nice.
So, yeah, it was super stressful though.
Yeah. I remember having to get somebody served. It was like a principal of the school, and it was the last possible day, and my process server had to sneak in through a locked door by tailgating somebody to track him down and serve him. And then I remember having to serve my ex by publication once because she wouldn't accept papers. She kept hiding and refusing service, so I had to put her in the newspaper.
Wow.
It's
Yeah, that is.
that's how they win. They don't care. They don't feel bad about it. They find all of the rules that are meant to protect people's rights, and they exploit them. Everything is a weapon to them. Everything is an opportunity to be exploited, cheated, tricked, gamed. That's how it is. So anyway, it sounds, there's a few comments here. Let's see here. Matt Mitchell says that his judge viewed a video, considered it, and declined to rule in his favor to make it difficult to appeal. And he asks me if that's exactly what it does. And yes, Matt, if he refuses to consider evidence, it'll reverse on appeal. If he does consider evidence and having considered it finds that all of the other evidence factors against you, that is incredibly difficult to win on appeal. Most of the time, you can't do anything about a situation like that, and it's disappointing, but some judges do that. And basically, his argument, Matt B, is that he didn't ignore it, that he did consider it, but that having considered it, he didn't believe it, or that everything else that he considered weighed more heavily in the other direction. So your main question is, does that make it hard to appeal? Yes, it does. If he said, hey, I'm not going to even listen to this because I don't think it applies, way different situation on appeal. We got built for 240 saying, how valid are screenshots of text in family court? I think they have to be authenticated. If your ex doesn't object to them, they should be fine. But some people will have an attorney who is savvy and they'll object to those screenshots of texts. And it depends on what the objection is. They may say that they want more complete record of the texts, like they might want all of them, not just a piece of them. Or they might say that they're fake and that they were never sent by their client, which case you have to usually go and get an expert from the phone company to testify as to their validity. We got, oh, by the way, guys, Megan Watson, when we talked about her judge was my judge. We both shared the same exact judge in Reno. His name was District Judge Chuck Weller. And right now he's been disciplined and has his his imposition of discipline is on appeal in the Supreme Court of Nevada. So we're kind of watching that. Megan and I were wondering what's going to happen to him. We got Matt Mitchell saying, judge cited res judicata overrides Texas statutes. What? Domestic violence evidence is admissible if it has happened within 2 years. Judge is forbidden from using. That sounds like that judge is wrong. Um, that's wrong. That should have been challenged on appeal. And anyway, continue with your story. I think we caught up on the comments.
Oh, I mean, the wrap up of it was probably not as strong. Yeah, give me 1 second.
Mm-hmm.
Yeah, so when it comes, could you still hear me?
Yeah, I could mute you so the viewers can't hear you if you need a few minutes.
Yeah, you can mute it once.
All right, so I've muted him while he sorts something out. It sounds like his kid and him are trying to get something taken care of. But anyway, any other questions or comments you guys have after he wraps up the end? My understanding is that he had built such a good case going to the evidentiary hearing that she didn't even go to court. And I showed you guys, actually I have it on screen, one of the visual aids. This is one of the graphics that he put together for the court. There are actually another couple that he put together that were really good, but they will expose his identity, so I'm not going to put them up. But he ended up putting together. Okay, he's back now, so I'm going to bring him back on. So I've
Yeah,
just connected you
if
so they
you
can
want
hear
to
you again.
show if you want to show the map one, have you shown that?
I haven't shown the map one. I'm going to try to show it in a way that keeps your info off. So while you're talking to them, I'll pull it up on my screen and then I'll slide it over when I've got your name and stuff off of it. Just a sec.
All right. Yeah, I'm good with that. So yeah, essentially, I just did a lot of prep work, made sure that I had all my exhibits organized extremely well. And the thing that I think was the strongest win in my sense is I was able to literally anticipate every single argument that would be against me. So going into it, I automatically knew that FCS, even though that I felt that it went good, the mediator, when we had went on this last time, I felt she was kind of in my favor because we were actually spoken to separately, and she kind of indicated to me that she didn't believe that the mother was on vacation, but it was just my assumption that, hey, she's going to say that, she should stay with the mother. But what I did in terms of um, shielding off that argument was I'd actually investigated the guy that she had married, my baby's mom, and it had just so happened that while she was arguing for a move away request and saying that this was in the best interest of my daughter, um, she was actually, her husband that she had, moved for this move away request was going through an eviction. Was actually going through a summary ejectment. So that's when like the sheriff's department is involved in like literally physically removing you from a place. And then what just happened to be the most beautiful coincidence in the world is the first mediation we had ever had, the same exact date that they had said, hey, the child should stay with the mother, was literally the same exact date that her husband had got issued a criminal summons. So within my motion, I had just basically argued it that, this could easily be the worst family court services recommendation that could ever be made, but it's also the best example of when any type of recommendation like this should only be referred to with looking at the evidence. Now, when it comes to the evidence, these hearings are only 20 minutes, unless you, and this is in California, unless you specifically ask for a long cause hearing, they're always going to default you to 20 minutes, and you're
Mm-hmm.
going to have literally no time. And in my county specifically, you'd have to look for yours, but there's a lot of instances where they actually don't even have like court stenographers, and they're not even recording the hearing. So if you have to double back on appeal, you don't even really have anything to stand on because you only have the minutes of the hearings. And you also have to basically make it a point to say, hey, I want this entered into the minutes. So unless you can convince the judge that you need a longer hearing, it's not going to be recorded. So this is something that it doesn't, yeah, all this information is not appearing right here, but basically I'd had a graphic designer. I run an agency, but if anybody can go on Fiverr.com or Upwork and basically get their data organized in a way that basically depicts, which was this is like, this is how many times my child's been moved with her mom,
Mm-hmm.
you know, and she's a baby still,
I pulled it
anytime you
up on
can just,
screen, by the way, so they can see it while you talk about it.
oh,
It's
okay.
it's up on screen.
Okay, cool. Yeah, so this is just like one example of how I took the data, which was factual and backed up through text and like authenticated documents, that I can prove this, but I condense it into a way to where visually it's way more impactful, and I can just show it to the judge and they're looking at it like, holy shit.
Yeah, so I mean that's I do have a couple of things that I want to talk about. So the first thing you said, long hearing, we call them evidentiary hearings here. We have motions or hearings on law and motion that are typically 15 minutes, 20 minutes, just like you described. And yes, you do have to ask for, well, not expressly. If you file a motion and it contains factual disputes, the judge is supposed to notice set an evidentiary hearing. So it sounds like California is much more perilous because if you don't know what you're doing there, you won't be able to appeal because when it comes to the submission of evidence and testimony of witnesses, you can't do that at one of the what you call 20-minute short hearings. Those hearings aren't meant for that. That's not the point of them. The court can only really make findings if your ex agrees. So, like if you accuse them of something and they admit it, the court can make that finding. But if they deny it, it's not appropriate for the court to over their objection without swearing people in and allowing the full, presentation of evidence and witnesses. It's not appropriate, at least in Nevada or anywhere else, I imagine, for a judge to do that. So the other thing, oh my God, you guys don't even have video recordings of your hearings. They just have minutes.
Yeah, yeah,
That's
they
it.
don't. Yeah, it's in the county, and I'd actually recently found this out because I was looking it up because I looked up the judge and found that he had basically, when he was a lawyer and practicing law, he basically worked with insurance companies and was, dealing with appellate type decisions. So I
Yeah.
was like, okay, I cannot lose going in with this guy because he's probably going to rule in a way to where winning on appeal against him is going to be next to impossible because that was literally his, area of law that he practiced in. So I'd looked it up and found that, in the city where I lived in California, basically they had removed that base to just cut costs to save money. So
Mm-hmm.
they stopped recording them unless the hearing was over 40 minutes,
Mm-hmm.
there was no recording of anything.
Wow. So yeah, in Nevada, yeah, if you don't have a transcript, you can't appeal with extraordinarily rare exceptions, the most impossible types of exceptions that I'm not even going to talk about. You have to have a transcript. And if you don't have a transcript and you have a video, you can make a transcript. But if you don't have a transcript and you don't have a video, that's it. You're done. You can't minutes and minute orders. They don't consider those final written orders for the purposes of an appeal. And even if they did consider it a final written order, you still would need the transcript anyway. So in Nevada, that would totally ruin a person's opportunity to challenge a judge's decision. We do have some hearings here that aren't recorded still, and those are like small claims are recorded. Summary eviction hearings in some courts aren't recorded, for example. And I think discovery commissioners proceedings, stuff like that, oddball stuff, that's mostly attorney stuff. Well, no, summary eviction, that's a lot of everyday people. You just have to know, one of the videos that I put out there on court reporters and the importance of getting a transcript talks about how you need to, at least if you're watching my channel and you want to challenge an order, you need to look and see if that hearing is going to be recorded, and if not, think about bringing a court reporter. So I think there was one more thing that you mentioned that I wanted to cover, but I just spaced on it. So I'm going to take a look at some of these comments here. We got Matt B says, being accused of mental abuse relies almost completely on guardian ad litems. It's very dangerous and very expensive to hire private psychs to rebut one. And then we've got Build 420 says, wife had him arrested on domestic battery. Attorney turned evidence over to the DA and dropped his charge. That's good. So nothing. Anyone have any questions for Rob before we wrap things up? I don't know if you wanted to kind of come up with a conclusion or if you're pretty much good, Rob.
Yeah, I can walk through the conclusion on it. So
Okay.
it ended up not being this massive battle in court. So when the ex parte had happened prior to us going for the modification, and I'm talking about the ex parte when she disappeared with her, she appeared telephonically. She had never went to court, so she knew enough about, hey, this is how I can appear telephonically and do it that way. So I didn't have to really serve her for the next hearing because the judge told us and told her when it would be. But I did later, as I'd said, had to serve her with the declaration to get that, so she had time to rebut it or respond to it. Well, she ended up just not coming to court, which is the most bizarre thing in the world. And I think that she was really, I kind of think it took the air out of her when she read it because everyone that I think read it kind of, it looks like a lawyer would have put it together. It's backed up by law, it's backed up by precedent and stuff like that. And the evidence, though, in the exhibits were extremely strong. and there are things that she didn't even know I had, and it just really kind of painted the true story of what I saw versus what the world saw. And that's what I was able to actually finally introduce in the court after 2 years. So she was given that, and then after that, it feels like she really just started being, you know, just when she was served and we were leading up to the court, we were talking again, and things were kind of like, she was being fine with it, and it was like she knew what was going to happen, so she was kind of being more positive. And even the day before, we had talked, and it's like, we got court tomorrow, over the phone, and she was talking to Zoe, and she's like, yeah, and I told them that she should be appearing telephonically, and they ended up trailing my case to the last one, so it's like she got every opportunity. And then right after the hearing, she called me and asked me what happened, and it was just, it was just
She on
bizarre.
purpose didn't go, and she's like, "Hey, so what happened?"
Yeah, and I told her, and she just, like, hung up on me. And then it went from that to, this isn't right. A child shouldn't be taken from her mother. Then it went from that to, raise her how you want. I'm not going to have anything to do with her anymore. I'm not going to call you anymore.
Yeah, they
To
make it all about
her,
them.
yeah,
It's all about their own
telling,
emotional wounds.
yeah, telling our daughter bye and all that. And then, um, which I've saved all that stuff if I need it later. But
Yeah,
now it's kind of back to her talking. But it's just strange to go through it, such an intense, like, a mental psychological battle. Because I mean, yeah. I mean, you got to really want it too. It's like, I think some people, and this is just kind of advocating on both sides, go into these types of arguments and fights trying to beat the other person. But even winning, you're just winning a set of new challenges. Like, I'm a single father. I work from home. I get up at 3 to do my thing before my daughter gets up. You know
hmm
what I'm saying? And then cook her breakfast and all that. So it's like, you got to really, and I've heard this in your videos, Alex, where, like, how the abusers win and things like that, because there's so much that happens, and that it just becomes like this real psychological battle to really press, because it's just extremely stressful, and it
yeah.
does impact so many other areas of your life,
hmm
that it's definitely an uphill battle.
You got a comment here from Matt saying, Matt B says, "How in the world were you able to follow her from coast to coast? That's an amazing show of a parent doing everything possible." And he's also wondering what states you were filing in.
So, it was California. That's our home state. California to North Carolina is where that happened. But California has always remained the home state. It is today. I'm actually lucky because I work online. I do digital marketing and things like that. So in that sense, it was an opportunity a lot of people didn't have. I had to sell everything I own and go through to make that move quick. But that's what made it possible.
Megan says a lot of people struggle and are overwhelmed when they are faced with these issues, then that leads to their cases being prolonged and their situations potentially worsening. What advice do you have for anyone who may be who may be in the shoes when you started this journey through the legal process? Maybe it sounds kind of like a hindsight question, like what would you do from the beginning differently? It's kind of what I'm getting from her question.
Yeah, I would have. It's one thing I wouldn't have done is I wouldn't have agreed to things. I felt that agreeing to things would show that I am trying to meet halfway and co-parent. But when you're dealing with certain people that have no intention of doing that, that will be weapons that they use against you later on. So that's the one that I would say above anything else. Outside of that, like, what you have to do, even when things are going good, which I did when it comes to, for example, sending the text and to validate when I picked her up and when I dropped her off. Things were going good. I'd take her to run her errands here and there and stuff like that. But because of the background that I've had with her, I knew that I just needed to make sure that if a time comes, then that information exists. Because if it doesn't, it just literally becomes my word against hers. And with my background already, like I had a huge obstacle to overcome. I mean, 16 months of my daughter's life, I was in prison. That's
Yeah.
something that, for a gun. So it's like things like that. You got to be doing so much right, and you got to be, you know, focused on that 100%.
And in the end, I don't know about you, but for me, those first couple of years, I was always so concerned about her feelings and how bad she must have felt to not have gotten what she wanted. And I don't know about you, but eventually I realized it's really all about him, like my son. Like he was going through all this suffering just because we were inadvertently treating him like a possession. We were so obsessed with our parental rights and we weren't paying attention to the trauma that he was suffering. That's one of the things Megan said. Congratulations for sticking with it and creating a path for your child that sheltered her from so much potential trauma. That was her last comment.
No, I appreciate that.
Yeah. All right, guys, I think we're going to head off now. And thanks for watching. Of course, the replay is going to be up probably in a couple of hours. And thanks for coming on, Rob.
I appreciate it. Thanks for having me, Alex.
You're welcome.